name is Upasana Khatri, and I am a staff attorney at EarthRights International at our Peru office in Lima, which focuses on the Amazon and Andean region. And today, along with my colleague Tamara, we will be presenting on various strategies that EarthRights has practiced and pushed forward in terms of protecting Indigenous peoples, not only in Latin America, but in some of the other regions of the world that we operate in.
Thank you so much, Upasana and Tamara. This is Alejandra Pirro, the webinar coordinator and facilitator, and I just wanted to warmly welcome you, Upasana, and also Tamara Morgenthau to our webinar series, which is starting today. So on behalf of the NBSAP Forum and the Equator Initiative, we definitely would like to welcome you all to this month-long webinar series. And the title of our series is Strengthening Indigenous Peoples' Capacity, Leadership, and Rights. And this week's theme is on international legal frameworks and Indigenous rights. And our webinar today will focus on international law and Indigenous rights, national implementation, and access to justice. So we warmly welcome you, Upasana and Tamara Morgenthau. Thank you, Upasana, for your introduction. I will just reiterate that Upasana is a staff attorney with EarthRights International's Amazon Program Office in Lima, Peru. And Upasana has been working at EarthRights International since 2014, when she started as a legal fellow in the Washington, D.C. office. She is also counsel on the Kyobel versus Cravath case, which involves the Shell Corporation and the Ogoni people of Nigeria. Upasana has also been heavily involved in the Doe versus Chiquita Brands case. Today, she is currently practicing in both U.S. federal courts and within the Inter-American human rights system. We'd also like to introduce Tamara Morgenthau, who's joining the seminar as well. She is also a Bertha Legal Fellow with EarthRights International office based in the United States. Tamara's work focuses on holding U.S. and Canadian corporations accountable for human rights and environmental harms associated with their global operations. Tamara has been involved in U.S. litigation, including Sahu versus Union Carbide, and submissions to UN committees regarding Canada's extraterritorial obligations to regulate its corporations. So we thank you very much for accepting this invitation and taking the time to join us. I just wanted to take a few seconds to explain what our webinar today will focus on. It will address international and regional Indigenous human rights frameworks and how they can be applied nationally using specific examples. The discussion will also highlight the mechanisms at the international and regional level through which Indigenous peoples' communities can better access justice. It is important to note that although there's a significant number of international legal standards protecting Indigenous peoples' rights, implementation remains a challenge, and violations of those rights continue to threaten the integrity of many Indigenous peoples' territories and communities. So we have felt the NBSAP Forum and the Equator Initiative the importance of addressing these issues through a webinar series to strengthen capacity at all levels. So I will take a moment now to address some of the rules and dynamics of our webinar. The microphones will be muted during the presentation to reduce interferences and facilitate the communication, particularly from our presenters. The presentation that Upasana and Tamara will give will be about 45 minutes, followed by questions from the audience and discussion. We ask the participants to please send in advance your questions, or you can use the raise your hand application that's in the control panel of the GoToWebinar. And if you want to speak and the connection allows it, we will of course open the microphones during the Q&A, during the question and answer session. And I just wanted to reiterate that many of our participants may not be English native speakers, so we just would like to remind our presenters the importance to speak slowly and clearly to facilitate everyone's understanding. So I kindly invite Upasana and Tamara to please present their work. Thank you so much and welcome.
Great, thank you, Alejandra. This is Tamara, and I, as Alejandra said, I'm a legal fellow in the U.S. Office. Very quickly, I just want to introduce our organization, which is EarthRights International, and we have offices in the U.S., Thailand, Myanmar, and Peru. And collectively, our organization works with communities, often indigenous peoples, who are impacted by large-scale development and infrastructure projects. And we work with them through providing legal trainings, direct legal advocacy, and through campaign work, which often works on ensuring, the protection of those communities' human and environmental rights. So today, our presentation is going to focus on some of the work and strategies that our organization uses in these contexts.
Thanks, Tamara, and thank you again, Alejandra, for the introduction and for allowing us to participate. I just wanted to start off right before we jump into things to, again, as Tamara mentioned, this presentation only covers sort of a glimpse of some of the various legal strategies that are available in this field, that both in terms of what EarthRights practices and generally. So this is in no way an exhaustive list, and some of the examples we have today will focus more on the litigation side of things, and litigation is when you actually bring a case to a court, usually in our context for civil damages, not for criminal liability. So in that respect, this presentation is a bit limited in terms of how many other, options are available through campaigning, for example, through legal advocacy, through non-litigation judicial redress. And so I just wanted to clarify that this isn't an exhaustive list whatsoever, but that we are happy to share our other resources and links to some of our publications or our partners' publications that cover other types of strategies as well. The way we set up this presentation is an important thing before you decide to develop a case, whether it's to bring a case to the court or to prepare a complaint to present to a UN body, is to actually document the case. The actual bringing the grievance to the appropriate audience will usually be the last step. There are various steps necessary in terms of building the case and documenting the relevant facts that are very essential and also important to help you decide which legal recourse is actually available in your situation. And so we've set up this presentation as a sort of a walkthrough to help you identify the various issues, the relevant actors, and then from that information decide which legal strategy is most appropriate. So just starting off, this is basically the main steps we've identified in terms of what you should do before you embark on the proper avenue for a legal remedy. And I'll go through each of these specifically, and then in our fifth bullet point, the evaluating of available legal strategies, will actually give you specific examples of strategies EarthRights has used, including our specific landmark cases. And so the first step will be to identify the harm, whether that's imminent, which means whether it's about to happen or already existing, and the cause of that harm and the origin. And I'll explain a little bit more about how to properly define the cause versus the origin. Second, you have to identify the actors involved, and these are the perpetrators of the harm, and as well as those that will be affected by the harm. The latter will obviously be the communities, but the former, the perpetrators, can be a variety of different actors. It can be institutional, financial institutions, private companies, or even the government. Third, an important aspect of building a case is to create a timeline of events so that you properly document when the harm occurred, any decisions that led to that harm existing, as well as any remediation efforts, just so that you have a proper timeline and are thereby able to build your case and legal arguments better based on causality and other issues that are relevant. Fourth is to identify whether there has actually been a violation of a law and a right, because even if there is a harm, unless there is some violation of a legal norm, whether domestic or international, then that ultimately decides whether there is a legal recourse and what type of recourse is available. And fifth is to evaluate, as I mentioned, the available legal strategies and remedies. So first, for identifying the harm, its cause, and its origin. I've given two examples that sort of break down how you identify these various elements. Example A, which is something that we've witnessed in the Peruvian highlands where we operate, is harm caused by violent attacks against a territory or a community. And this is something we've seen in the Cajamarca region of Peru around a gold mining operation. And so the cause directly is armed groups, specifically security forces, who have tried to repress community protest against this mine. And then the origin of this issue is the actual gold mine, whose owners have contracted security guards, or in the case in Peru, the actual national police, to intimidate the opponents of a mining project. And so, again, it's very important to trace the harm, the cause, and the origin, because then you will be able to break down which actors are involved in whatever relevant step in the process the project is at. Example B is another issue we have encountered a lot in Peru, and that the harm there are health problems and deaths caused by water contamination. Direct cause is oil spills in the river that is in turn used by the community. And because of their use of this contaminated oil-filled river, that has led to various health effects, including cancer and premature deaths. And the origin is ultimately an oil extraction and pipeline project, as well as the national regulation and decree that authorize this type of project. And so this example is important because while the actual cause of the harm, the origin can be from the development project, ultimately what you might need to target is the domestic law or regulation that allows this project to even exist. And so you have to attack on both fronts, on the actual project level and then also at the legal level. And so going on, identifying the actors. And so these are various questions you have to ask yourself, and again, will determine what type of legal recourse is available. Is it a government or state or governmental entity that is responsible for the harm? Is it a company or a private entity? Is there both? In the case of the security contracts in Peru and the intimidation of protesters, the private company is the one that contracted the national police, but at the same time, it's the Peruvian government that has allowed this contract to exist and has allowed the private use of public police forces. And if it is a private company, more questions you have to ask is it a subsidiary or is there a parent company? If the company operating in Peru, for example, is a subsidiary, then you might need to target the parent company, which may be located somewhere else, for example, headquartered in the United States. And so that also broadens what recourses are available. Furthermore, you can ask yourself, is there an entity or institution that has control or ownership of the project at issue? For example, an international financial institution that is responsible for funding a very problematic project. And that way you can actually target the source of the money of these projects in order to find accountability. And so, yeah, so with example B, which was the example of the oil spills, the actors in that situation is the oil company, the private entity responsible directly for the spills, as well as the state, if the state has authorized national regulations or decrees that allow for the existence of these operations that have very low environmental standards and there are no environmental safeguards in place. And so you'd want to target both the oil company for reparations of the harm and also the state so that they change their policy and enforce better environmental regulations and accountability mechanisms for the private companies operating. The next thing you need to do is to map out the harm. And so this is what I went back, this is what I was mentioning in terms of documenting and creating a timeline. And this is something you should start and maintaining a record of the problem and conflict as soon as the harm is discovered. And why is this important? I think I mentioned this a little bit further, but oftentimes when it comes to litigation or bringing a case to an actual court for damages, for reparations, there are often limits, time limits in which you can bring the case. And this is called statutes of limitations. And oftentimes you'll see companies by whatever means or other actors trying to create obstacles that prevent you from bringing this case in a timely manner while it still can be litigated in the court. And examples of these obstacles are not effectively publicizing their link to this project. If the community isn't aware that a company, for example, a US company is linked to this project, then they will never know that they could actually find reparations and find accountability by suing the company in the US, because from their perspective, this project might seem entirely local, for example, entirely a project in Nigeria, entirely a project in Peru, when in fact there are either international financial institutions funding the project, or there might be parent companies that have essential control over how the project operates in the ground. And so it's very important to start documenting early and being able to identify the harm and the causality as early as possible through record keeping of, of looking at these questions, like when did you discover the harm or changes in your territory? Why do you think these changes are linked to the presence of the company? Has the project already had or will it have direct effects on the community, for example, displacement? Another important thing is, do contracts exist between the community and the state, or between the state and the private company? All these questions will be very essential in the long run in terms of deciding who can actually be held accountable and what means of accountability are available. And another very important question, especially related to Indigenous peoples, is have you signed any contracts related to the project? As many of you as I'm sure many of you know, states and private entities try to get around their obligations around environmental impact assessments and public consultation laws through very bad faith means. And this includes having communities sign documents that, in no way authorize their consent to a project. It might be the form of misleading what the document even means, which we've seen various times in the field. And so keeping track of what you've been presented by a community or by the government, what community members, whether collectively or individually, have signed is very important, because that in the long run can affect your legal rights as well as your ability to challenge any documents that presumably give consent over a project that actually hasn't been consulted on at all. And so this is just what I was saying before. A timeline is very important. There are often statutes of limitations. So just moving on. And fourth is identifying the legal violation. So oftentimes the harm will be very obvious. For example, an oil spill, intimidation of protesters. But also, is there a legal violation? So like I said, unless there is a clear violation of a legal norm, a domestic norm or regulation, or an international standard, that question will ultimately decide if there is a redress and what type of redress is available and what platform it is available in, whether that's at the local level, in domestic courts, or at the international level, for example, in front of the UN or in front of a regional legal system. And so a violation of law, these are the elements you would look to decide whether there has been a violation of law, is a negative change in the conditions of the community or its territory, which is the harm, that you can attribute to the actions or omissions of a third party, the actors, and these actions are in violation of a legal norm. So going back to the example of the oil spills, we mentioned that the actors, the violators, are both the oil company and the state. And then you have to identify what exactly they're violating. They're violating, the right to life, the right to good health. But where are these rights actually protected? And so in this situation, the oil company, the violations may exist in international norms and domestic laws around free, prior, and informed consent, including constitutional provisions. At least in Latin America, in the constitutions of Ecuador, for example, there are very clear provisions allowing for FPIC, for consent and consultation over projects affecting indigenous rights. And there also may be domestic regulations, environmental regulations that the companies could be violating by not implementing proper environmental safeguards that in turn lead to oil spills. Further, are there civil rights that are being violated? In the US and in Europe, these are called tort laws or personal injury. And so these can be, even when this is when there's been some sort of bodily harm, and can also be when there are environmental factors that affect a person's enjoyment either of their body or their property. So oftentimes you hear of nuisance law in the US, and nuisance law can actually be applied when there have been environmental effects such as flooding that affect a person's enjoyment of their property. So these are an example of some of the civil rights that may allow you to have an action under civil law in the US, in Europe, and also in other parts of the world. And then you want to evaluate the legal strategies based on the type of violation. So if the state is the actor, the remedies may be administrative or constitutional in nature, or involve international judicial actions. So this is a little bit more focused on our experiences in Latin America, but there are parallel mechanisms and systems in other parts of the world. So for an example of domestic, administrative, or constitutional actions that might be used as remedies one example is amparo actions in Latin America, including Peru, which are sort of injunctive relief actions which occur in the event of constitutional violations, including violations of the right to life. And this we've often evoked when there's been a very urgent harm.
It says something about network difficulties.
Oh, okay. When there are very imminent threats, for example, if there is a dam being built, but it's in violation of a constitutional right, then this gives sort of a injunctive relief, at least until some of the more substantive issues are addressed in terms of the project. Other things you can do is to file complaints directly to relevant government offices. For example, in Peru, we often write complaints to the relevant ministries, whether that's the Ministry of Culture, which deals a lot with indigenous peoples, or Ministry of Oil and Development. Other mechanisms include regional human rights systems, which I won't go into because at least my understanding is a lot of our current audience might not be working within the system, but just to give an overview, there are two bodies within the Inter-American Human Rights System, which is the Court and the Commission, and there are different remedies available in each. In the Inter-American Court, which takes on cases that are originally brought in the Commission but then passed down to the court for binding decisions. There's also an option for precautionary measures, which gives also similar injunctive relief when there's a risk of urgent and irreparable harm. For example, a project that might be affecting the rights of an Indigenous group in voluntary isolation. If there is a very imminent risk for that group, then the petitioner has to show what that harm could be and that it's urgent and irreparable, and so of such a large scale that there'll be an irreversible impact. And then there are also options in terms of legal strategies at the international platform, including the United Nations, which we will go into a little bit more on later slides. But some of the, there are various mechanisms available in the UN. One of the most common ones we've worked with is presenting complaints or grievances to the proper UN committees that are tasked with monitoring state compliance with a treaty to which the state is signed on. For example, an International Covenant on Economic, Social, and Cultural Rights. Another option we've practiced is writing a letter to a UN Special Rapporteur. And although this often results in maybe reports by the Special Rapporteur that addresses the issue, the problem, or involves site visits from the Special Rapporteur to a project, to a community. And so while this might not have binding legal impact and to the same extent as a judgment, it does lend visibility to an issue. And so a lot of these strategies, including the UN, the states might not be entirely receptive to a UN's opinion on what they should be doing. But either way, these strategies are very important in terms of lending visibility, bringing the issue to an international audience, because oftentimes it's public pressure, either on the state or even the company in violation, that affects change. Another mechanism that I won't go into too much now, but just want to put out there is the Organization for Economic Cooperation and Development. And through the OECD, if a state is in violation and it is a member of the OECD, you may file a complaint against the state with the state's national contact point. And this starts a sort of voluntary mechanism that also may be available if the violator is a private entity, for example, a company or an NGO, in which case you would have to file a complaint in the country where that company or NGO is headquartered. But again, the limitation of this is that it's voluntary in nature, and so this doesn't have a binding impact, but often depends on the openness of the state or the private entity to cooperate in the process. I'll have Tamara explain a little bit of the UN mechanisms, or at least some of the main ones that ERI has been working on, just briefly.
Sure. So as Upasana mentioned, within the UN, there are numerous mechanisms and treaties set up that focus on Indigenous peoples and, offering protection of different rights. So we're just going to focus on two options to utilize the UN if there's either been a violation of those rights or a foreseeable violation in the future. And these can be applied, this is going to speak very generally to treaty bodies, and what we're referring to, there's numerous treaties, so like the ICCPR, the ICECSR, which Upasana mentioned. There's also the Convention for Elimination of Racial Discrimination, the Convention for the Rights of the Child, the Convention Against Torture, and all of those within them have different protections for Indigenous peoples, which include, protection of self-determination, as well as protection for, rights such as, consultation, environmental rights, right to health, employment, protection of culture. So within the different treaties, if there's a violation, there's a few avenues that you can take. One is states are often reviewed if a state is a signatory to a treaty, they are reviewed every number of years to assess their compliance with their obligations under the treaty. And it's an official process that takes place where the state submits a report to the committee outlining everything they're doing to comply with their obligations. And through this process, there's opportunity for civil society to submit what they call shadow reports to the various treaties, where you outline specific concerns and highlight violations that you think the state is that the state has rights that the state has violated. So ERI, along with other partners, has submitted recently reports to the Committee for Elimination of Discrimination Against Women, and is now working on a report for the Committee for the Elimination of Racial Discrimination, focusing on Canada's extraterritorial obligations. And in the context of the CERD, the Committee on Elimination of Racial Discrimination, we are focusing on, Canadian companies' operations abroad and their impact on Indigenous peoples, and profiling different examples, and focusing on, the right to free, prior informed consultation, and other economic and social rights, as well as violation of rights, violation of physical rights. And so one thing, that's something to consider. And what that does is it doesn't result necessarily in specific findings of one example or case, but it can result in the committee finding that, or expressing concern over the state's actions, and putting forth recommendations for the state to follow, to comply with their obligations. So it is a way to, highlight a specific example and put pressure on the government. Another option for treaty bodies is you can make individual complaints. So this is if you do want a specific finding relating to a specific fact scenario. And it can involve past violations, or something that's currently ongoing, or anything that you can think will be a violation that will occur in the future. And if you think that it's imminent, a lot of committees, specifically the Committee for Elimination of Racial Discrimination, has like an urgent appeals. So you can, bring something that's like requires immediate attention to the committee. And what this results in is the committee will evaluate your claim, and if they think it's credible, they will approach the state directly and ask for information on the allegations. And it does result, you do get a definitive decision from this process that as to whether the committee thinks there has been a violation. But this process can be quite timely. It depends on the different committees. And the decisions aren't binding. They can have persuasive authority, and depending on different states, it will depend on whether they decide to follow them or not, but they can, again, be important for advocacy efforts. And an important consideration, there's two important considerations for the ability to use this strategy. One is the state actually has to sign a specific treaty that allows them to participate in the individual complaints process. And the second thing is that there is an obligation to exhaust domestic remedies. So that requires either going to the national judicial system or showing that there's an unavailability to do so. Another option is to go, what Upasana discussed, to different special rapporteurs. So the UN has numerous special rapporteurs that are experts on specific topics. There is a specific special rapporteur on the rights of Indigenous peoples. There's also special rapporteurs on, the right to housing, the right to food, and individuals can submit complaints to special rapporteurs for issues that fall within their mandate, and they can then get the special rapporteur to investigate and write a report or a recommendation on their specific issue as well. Another advocacy option for special rapporteurs is that they are frequently writing reports. So you can ask the special rapporteur to visit your country, flagging that there's, potential violations for issues within their mandate. And if the special rapporteur is able to come, they can write a broad report. And this, again, can be a useful advocacy tool, drawing attention to issues that are, important and violations that, you think warrant attention.
Thanks, Tamara. And yeah, I just want to reemphasize, as Tamara mentioned, that this is an important means for advocacy and adding visibility to an issue. Some of these legal strategies we've discussed and that we will discuss right before we conclude are very lengthy processes. They often take years to litigate. For example, our case against Chiquita Banana for funding human rights abuses, paramilitary violence in Colombia has only recently been declared, it has been decided the case can stay in the U.S. and not Colombia. And so it is still considered in pretrial proceedings, even though it was originally brought to the court in 2012. So these processes can be very lengthy. And so when there is an issue of urgency, oftentimes non-litigation might also be important in terms of adding pressure on the community or the government to change its practices. And as Tamara mentioned, I haven't gotten too exhaustively into the Inter-American system of human rights. I'm happy to answer any questions if there are about specifics about it, but as Tamara mentioned with the UN complaint system, there is often a local exhaustion requirement. In the Inter-American system as well, you can't bring a case to the commission or the court unless you've shown that you've exhausted any available remedies there are at the local state level. And then only after you show that either the domestic remedies aren't available or that the state is not effective in protecting and ensuring that these remedies are available, only then can you turn to a regional and international system, oftentimes. So we just have two more strategies to share with you. I'm particularly excited about Tamara's presentation, which is a new strategy that ERI has spearheaded in recent years in the human rights field. But before we get into that, just wanted to, before we talked about what sort of remedies are available if the state is the one in violation. In the US, if the violator is a private entity or private company, the remedies will often be private in nature. For example, cases for damages, damages as in compensation in civil courts. Again, there are other strategies as well. You can try to hold a company criminally liable, or, if not personally, if a citizen doesn't actually bring, it's the state that brings a criminal prosecution, at least in the US, against the company. But there are ways for citizens to be involved to create pressure for there to be a criminal investigation. But we will focus here on ERI strategy, which is civil liability. And that's where you bring in legal action in the courts of the country the company is from. And obviously for us, our cases often involve companies that are from the US or has its headquarters in the US, and that allows for us to use US courts to get enforceable judgments against these companies. And so what happens is if the organization or institution, including, again, I want to reiterate, including IFIs, international financial institutions, and I keep bringing up this point because as you might look up on our website, we currently have 2 cases against the IFC for funding various projects, one in Honduras and one in India, that have resulted in Honduras in egregious human rights abuses, in India, very devastating environmental impacts. And so, it's not always a company, it's also a funding institution that can be held accountable. And you can bring the action in US courts depending on the harm. If the violations consist of serious human rights violations or seriously egregious offenses that are criminal in nature, as well as considered violations of international law, for example, torture, extrajudicial killings, war crimes, you may be able to bring the action under a federal US law or statute. For example, the ones that are often invoked in human rights cases is the Alien Tort Statute or the Torture Victims Protection Act. We have claims under the TVPA, the Torture Victims Protection Act, in our case against Chiquita, which I just mentioned. And like I mentioned before, you can also depend on state laws, and state in this situation, I mean, as you know, states like California, New York, not states as in country. And so there you find violations of laws of that state if the company is based there. And these tort laws can also apply, like I said, if the violations, if the harm is environmental in nature. For example, fires, floods, environmental impacts can fall under tort violations. And so example B that I kept going back to is actually based on a real case we brought in the US called Garijano. Oh, apologies, this was the last slide. This will be available to look at later. But so this is the case that we brought was Garijano v. Occidental Petroleum. Oxy is an oil company based in California. And so when we found out about this huge oil contamination that was going on in the Peruvian Amazon, affecting various communities, including 5 indigenous Achuar communities from the Corrientes River region, the communities and ERI presented a complaint against Oxy in a federal court in California, since that's the state where Oxy was headquartered. And this complaint alleged violations of California law, of US federal law, as well as international laws and legal norms, as well as Peruvian law. And Oxy, as I mentioned, there's oftentimes the companies will try to transfer the case to other courts, for example, the courts of the country where the harm occurred. And in the case of Oxy and in the case of Chiquita Banana in Colombia, this is often a strategy that companies use because they know that either the judgment cannot be enforced if they've already taken out all of their properties or asset out of the country, or if they know that the courts move slowly or don't have impartial judgments, or if the security risks are so high for the plaintiffs, for the victims in the country, that the case might be dropped altogether based on these security risks. So ERI was able to successfully demonstrate that the case should stay in the US to be litigated. And this happened both for our Garijano case as well as our recent Chiquita ruling on the same issue. And so in 2014, 2015, after years of litigation, the communities and Oxy actually reached a settlement through which the communities were compensated. And so this form of transnational litigation is sometimes limiting in terms of bringing it to the US requires it to be litigated against a US company. The harm has to be linked to the US in some way or to the company. But it is a very promising mechanism, especially for finding justice and for a community in a country where the domestic courts won't be able to offer the same kind of redress. And then briefly, I know we're running a little bit slower than planned, but Tamara has one more legal strategy that she would like to share, and this is the one that I'm particularly excited about.
Okay, thank you. So this, as Upasana said, is a new strategy for ERI, Upasana and I have both worked on cases involving this strategy. So feel free in the question period, you can direct questions to either of us. But to go into it briefly, what it is it's a U.S. statute that allows applications to be brought to a federal court in the U.S. to obtain information to use in a legal case outside of the U.S. So to break that down, this is a discretionary application, and there are certain requirements that have to be met that the US Supreme Court has laid out for us. And I'm just going to summarize what some of those requirements are to give you an idea of what one of these applications looks like. And then I'm going to discuss some examples of cases that we have worked on to show you in practice what this looks like. So some of the key elements are, the first thing that you need is an ongoing or planned legal case outside of the US. What does this mean? That means a case before a foreign court. It could also be public arbitration or a criminal investigation that's ongoing. The use of the language in the statute says, a foreign tribunal. So a foreign or international tribunal. So there is some interpretation of what this means, and there's also some questions. For example, we don't yet know whether an application can go towards supporting a case before a human rights commission. But one thing that's really significant is that the US Supreme Court has said this can include applications for cases that are in reasonable contemplation. So the case does not need to be pending, but it can be planned. And in a lot of countries, applicants are required to have evidence when they initiate a legal proceeding. So this is a tool that may be useful to allow applicants to gather that evidence to initiate their proceeding. The second element is that the target of the application can be an individual or a company, and they must reside or be found in the US. And they must have evidence that is relevant to the foreign case. So the first element is interpreted pretty broadly. Basically, the best case scenarios, you find an individual who lives in the US or a company that's headquartered or incorporated in the US or is doing significant business here. And that individual company must have evidence that you can show is relevant to the proceeding outside of the US. So either to building the case or to an issue in the case. Because the statute requires that the evidence that you're trying to obtain be for use in the foreign proceeding. The third element is that applicant must be an interested person. But generally, what this means is the applicant must be a party in the foreign proceeding, and that could be, a plaintiff or a defendant, but it also could be someone who's joined the party as an intervener or who has status as a friend of the court. But it's also broader than a party, and it could be someone who has the ability to file evidence to the court. So, it could be a victim of a criminal investigation who can then submit evidence, or, somebody else who has that ability. A few additional points as to elements, because I did say that this is also a discretionary application. One important factor is that you actually do not need to ask your foreign court to obtain the evidence before trying to use this tool. But it can be a factor that the court will consider if the foreign court has the ability to obtain the evidence you're seeking. So, for example, if the target, the individual or the company, is actually a party to the foreign case and that court can get the evidence directly, that would favor against granting this application. But if their evidence is beyond the scope of that court and they can't obtain it, that's, the best case scenario for using this type of application. Also, the applications, you can't bring it in bad faith, and you should consider making sure that it's not overly burdensome in terms of what you're requesting from the target. And the other thing that the courts will consider is, the foreign court and whether they will be receptive to the evidence. So just to show you a little diagram of what this process looks like, the first step, as we said, is you need the foreign legal proceeding, either one that's pending or planned. And then we have to identify that there is someone in the US that has relevant information. And if that's the case, then you can work with US lawyers to submit the application, and hopefully the court will order production. So one of the things that we really like about this strategy strategy is that it is a very collaborative process with, individuals and organizations and lawyers working in the, the foreign case, working with, EarthRights or our partners to bring these applications. And it allows the use of the U.S. courts to assist the foreign proceedings. So now I'll just discuss some of the cases that ERI has worked on. And more information, we can discuss in questions, but is also available on our website. So the first case is Campos Alvarez v. Newmont Mining Corporation. The first thing I'm going to this slide goes through some of the background facts for the case, and for, the situation that led to the foreign proceeding. And so Newmont Mining Company is a U.S. company, and through one of its subsidiaries, it's the majority owner of Minera Yanacocha, which is a Peruvian company that owns Yanacocha Gold Mine in Cajamarca, Peru, and has proposed, or years ago proposed, to build a new mine, the Conga Gold and Copper Mine, just nearby to the Yanacocha Gold Mine. That project actually right now is on pause, but the events that led to this case took place in 2011, around the time when there was the announcements of the proposed new mine. And there was widespread community opposition to both mines, involving environmental concerns and other related concerns about the impacts of the mine on the local communities. And on November 29, 2011, the police violently suppressed a protest against the proposed Conga mine. And it's relevant to know that at that time, the police did have a contract with Minera Yanacocha to provide security for the mine. So ERI worked client and brought the application on behalf of Elmer Campos, who was participating in the protest and was shot and paralyzed by the police while he was peacefully protesting on November 29th in 2011. As a result of that shooting, this led to a civil and criminal investigation in Peru against the government and police. And because the government, as I was saying, because the police had a contract with Minera Yanacocha, which is majority owned by a Newmont subsidiary, there was, belief that Newmont would have information that was relevant to, the relationship between the company, the mine, and the police, what happened on that day, what led to the shooting, and so that all of that evidence could be relevant to the ongoing criminal investigation in Peru and the civil action. So a flaw application was filed in 2014, and the other useful thing about these applications is it's quite broad in terms of what you can ask for. So, this application sought photos, videos, emails. It also sought a deposition, which is, sworn testimony from a member of Newmont. And this application was successful, and in March 2015, the court granted the application, and Newmont turned over significant evidence, which has been used in the case in Peru, and also granted a deposition. So just quickly to show another example, because I think it highlights a different way the strategy has been used, is an ongoing case. It's the Alberto Salcido Romo et al. V. Southern Copper Corporation. And this application with ERI brought, but actually it was an application brought through a network that ERI is building, which is the Foreign Legal Assistance Network, where we work with other partners and co-counsel to, bring these applications. And this application specifically was brought in conjunction with and, led by our partner at the Law Office of Lynn Coyle and an organization in Mexico, PODER, which stands for the Project on Organizing Development, Education, and Research. So some of the background facts, in August 2014, there was a toxic mining waste spill of over 10 million gallons of toxic waste from the Buena Vista mine in Sonora, Mexico. And this mine is run by a subsidiary of a US company, Southern Copper Corporation. And it's one of the largest environmental disasters in Mexico. It has affected over 24,000 people, you know, who rely on the water and the rivers for water consumption. You know, it has affected their crops, it has affected their animals. So, you know, there's been widespread significant environmental and health harms that have flown from the spill. As a result of that, there have been ongoing amparo actions in Mexico seeking to have the company and the government clean up the river and seeking compensation. So in April 2016, residents from some of the communities that were impacted by the spill, you know, filed one of these applications seeking evidence from Southern Copper Corporation. So similar to the case against Newmont, the idea is that Southern Copper Corporation, as the parent company, would have relevant information about how the mine operates, you know, what procedures were in place that needed to be followed to ensure that the spill wouldn't take place, or what procedures needed to be followed after the spill to, you know, ensure cleanup. So the application was sought for the ongoing actions, but also to obtain evidence for a newly anticipated environmental lawsuit, which, as I had mentioned previously, would require the evidence to be filed to initiate the complaint. So, you know, this, as I said, this application sought information for numerous proceedings and, you know, sought a lot of information about, you know, what the company knew about the conditions that caused the spill, their role, the damage, you know, the regulations in place, environmental management policies in place. And in June 2016, the court ordered Southern Copper to provide evidence. This application is ongoing in terms of obtaining the evidence at the moment. So just to tie things up, one more example, which I won't go into, but I do just want to mention, because it shows a different angle of the utility of this strategy, is the Menas versus Thompson case, which was an application filed by, you know, leaders of 3 Maasai villages in Tanzania to assist. They filed this request against Thompson Safaris, which is an American company, but an affiliate of a local safari company, the Tanzania Conservation Limited, that, you know, has allegedly participated in land grabbing and violence against the Maasai communities. And there's was litigation in Tanzania regarding the ownership of the land that the safari is operating on. And the owners of the American company are the same owners of the Tanzanian company. And so the application was filed directly against the owners as well as the American company, to get any information about the acquisition of the land, you know, land surveys, knowledge of the forced displacement and the violence that's alleged. And that application was also successful in obtaining information. You know, so as I said, this, as Upasana said, this is a new strategy. It's not a new statute, but it's new in terms of using it to support human rights cases outside of the US. It is something that EarthRights is trying to develop more broadly in terms of being able to get other lawyers and spread the word on its ability to, you know, assist in proceedings outside the US should there be information here. We have developed a fact sheet and a guide that's available in both English and Spanish on our website. And, you know, if there's ever questions that you want, I mean, if there's questions now, we're happy to answer them. But, you know, if there's a forum proceeding that you want to discuss with us or workshop with us, if there's potential use of this strategy, we're always open to discussions and talking about this in more detail.
Yeah.
So, thank you. I think that's our last slide. Yeah.
Yeah, thank you. And yeah, just to reiterate about the flaw, it's, as you've seen, a lot of our other legal strategies are somewhat limiting in geographically because, for example, in an American system, you have to be a member of the Organization for American States. But the flaw is very promising because we've used it to support litigation in Europe, in Africa, in Latin America, and so it's a very promising strategy. And like Tamara said, we're happy to share more about it. But thank you. And I know we went a little bit over time than planned, but if there's still time for questions, we're happy to stick around and talk.
Thank you so much, Upasana and Tamara. I think this was a very, very rich presentation. Thank you for sharing your time with our participants, for launching this webinar series. And this is very, very interesting and most helpful in terms of providing strategies through these examples, setting the stage on the issues that are at stake for many of these communities. So I think this has really been, what are the practical steps that communities can take? I'd like to now invite our attendees, our participants, to share their questions, comments. You can either write your question in the little question box that you'll see on the control panel, or there's a little picture of a hand to raise your hand to also participate in the Q&A session. So please use the control panel in the platform, in the GoToWebinar platform, and then we'll open up the microphone, or we can read your question, and that really depends on what you would prefer. Do we have any questions right now? Well, if people are taking their time now with some questions, perhaps I could start with a couple of questions.
Sure.
One would be on the special rapporteurs that you mentioned, where it's a wonderful mechanism through which, as you mentioned, of course, Indigenous peoples and local communities can voice a grievance and a complaint and have a report written and have a report then be used as an advocacy tool. But I believe the UN Special Rapporteur has to be invited, though, by the state to come and visit the country. So I was wondering if you had, they can't really respond to a community request directly. So I was wondering if you have any examples of or strategies through which communities can push a rapporteur to be able to come and visit their community through an invitation by the state, even if the state may be resistant, shall we say, to have a visit.
Well, so one thing just to clarify potentially on that is that the country visits, yes, as you mentioned, do require the government to give permission, but the allegation letters that can be brought from civil society or individuals or anyone, those do not require a country visit. So one strategy could be, to raise the concerns through an allegation letter and have the special rapporteur then reach out directly to that government and start that dialogue. And other ways, if the state is signatory to different treaty bodies and is up for reporting, it could be looking at a more holistic strategy, shining light on the different violations that you're concerned with, and that might put pressure on the government to allow country visits, because it just like in terms of their how they're presenting themselves and to the UN for specifically if they are signatory to different treaty bodies. So it could be something, you know, to look at other strategies as well, and that can work towards trying to get a country visit.
Yeah, and besides country visits as well, oftentimes you can keep track of reports that the special rapporteur is preparing, and often he or she will ask for civil society input, including, you know, representatives or direct members of communities. And so a lot of the times with, you know, one of the issues we've focused on or are focusing on more in EarthRights is the impact of conservation projects on human rights and when there's displacement around national parks. And so what EarthRights has done has been to submit, based on, you know, our observations from the field and literature, submit reports or comments to special rapporteurs who then use these in publications either to the Human Rights Council in their annual reports, or use it to in creation of safeguards, which is what the Human Rights Special Rapporteur John Knox on Human Rights and the Environment, he had a call for, you know, various issues that he should look at on his mandate. And so sometimes when there are these calls for feedback from civil society, that's also a platform to, again, bring visibility to an issue. Again, it might not be the most urgent relief available to the community if it's, you know, waiting for reports and then, which then can turn into more concrete actions, but it is very important in terms of, again, creating visibility for an issue that might otherwise be overlooked and a community that might otherwise not have a platform for airing these grievances.
Great. Thank you very much. I do see some hands and some written questions that have come in as well. So I'd like to give the floor to Daniel. Daniel Kobe. Hello, can you hear us?
Hello.
Hi, Daniel.
Hello.
Please, welcome.
Thank you very much, Alondra. It was great listening this very deep discussion on issues of human rights and leadership. And this is being the first one for me. I think it was very interesting, and I hope we'll get a chance to maybe for us to be able to have the PowerPoint, if possible. I don't know how it can work, because this is very interesting, so that I'm able to have the all the staff together to revisit the discussion. I don't know whether is that possible.
Yes, I'll have Alejandra answer this, but we were discussing with her that, you know, we would be very happy, probably send a bit of an updated slideshow. As I was reading through, I saw some information I wanted to add, but also if there's a platform, and I believe through the forum, that's how we can share documents. We're also happy to share some of our other publications, including the Foreign Legal Assistance Guide that Tamara mentioned, which is the how-to on how to bring cases under the FLA statute. And so we're happy to share those materials as well as the PowerPoint on this.
Yeah, because sometimes the internet is not very stable in this part of the world. So sometimes you tend not to get everything. But in the first, it was quite clear. But as we went along, we could miss some few words. But okay. I want just to thank you very much. It was very interesting and very rich indeed.
Thank you so much, Daniel. Daniel, we will make the information available. The session is being recorded, and we will also, it'll be available on the NBSAP forum site and also on the YouTube
Thank you.
Channel. Daniel, and I meant to say this, please introduce yourself, which organization and from which country you're coming from.
Thank you. I'm Daniel Kobei from Kenya. I am a community leader, and I'm also a director of Ogiek People's Development Program. So the discussion was very, very relevant to me because being a community leader, and most recently we won a legal case through the African court where Ogiek were declared to be indigenous peoples in Kenya.
Wow.
So this kind of discussion was very, very rich. Right now we are busy with dealing with reparations. So we still have some more work done. So the kind of information I've received are very, very relevant. And I was also happy to hear when you talked about how can we have a special rapporteur visit the country, especially when the government does not agree to make an official request for the visit. Thank you.
Great, thank you.
Thank you, Daniel. We'll now ask Donato Bumacas, please, from the Philippines, to introduce himself and then ask your question. Donato, welcome and hello.
Hi, Alejandra. Thank you for the opportunity. Hi, Tamara. I'm Donato Bumacas from the Philippines. I had been working with local and indigenous peoples through the Kalinga Mission. And now I'm connected with, but still connected with Kalinga Mission. I'm now connected with NCIP, National Commission on Indigenous Peoples. One of the things that I am so interested in is the foreign legal assistance, because based on my experiences, we had some legal issues between the indigenous peoples and companies based from the US. So my question actually on this matter is how much it costs to undergo this process, because as you know, if indigenous peoples will what do you call that, undergo such tedious process, it might it might be very costly, and it will end the because of the cost, the indigenous peoples might not pursue their case. So that's one. That's my first question actually, and I'll ask another question after perhaps receiving the answer. Thank you, Alejandra.
Thank you. Please.
All right, great. Thanks for your interest in this strategy and for your question. So a few things on costs. The first thing is there are some costs associated with filing a FLA application. The first is that there's a legal fee that you have to pay to file the application. That's often around $400, but courts can waive that fee if it can be shown that the party cannot afford to pay that fee. The second thing is if you request to get a deposition, so if you're requesting to have sworn testimony from the company, then you as the party do have to pay the cost for the deposition. So that could require a court reporter, a transcript. So that fee can vary depending on where it's set up in the city, but that can be it can range in a couple thousands of dollars. The other fee that could be applied is depending on how much evidence you're seeking. So documents, if it gets to be, specifically if you're requesting electronic documents, which often we do, so emails, videos, anything that's electronic, documents that they have on their computers, depending on how laborious the process is to retrieve those documents, the court can order the party to pay or contribute to the retrieval process. But that is you know, that's not given, and like in the cases that we've participated in, we haven't had that arise yet. But it is something to consider, especially when you're tailoring the request, you know, to how voluminous and how laborious it's going to be. Another option is that the court may require, you know, a party to pay a bond to the court, but that we haven't seen that. And again, if you have the status where the court has recognized that as waived the initial fee, it's unlikely that they would impose a bond. When EarthRights, you know, in the cases where we work, if we're filing an application, we don't have a lawyer attorney's fee to file an application. So yeah, so if you are interested in this strategy but cost is a concern, you know, we're definitely happy to discuss this with you further and see, you know, what we can do to make it possible if it's will be of use.
Yeah, and the only thing I want to add is sort of the contingent costs that might arise. Obviously, are costs of traveling to a location to do a deposition. Obviously, if it has to be done in the U.S., you might have to fly to the U.S. But again, besides EarthRights, there are other NGOs and other law firms even that we've connected with that are doing this kind of work pro bono. And so, you know, in a way that we hope to shoulder costs that would otherwise go on communities. The last cost that is very unlikely to happen is sometimes when cases go on appeal and eventually maybe the petitioner loses, and other types of cases as well, sometimes the court may order whoever loses the case to cover the costs, the attorney costs for the other party, the party that prevailed. But this is very rarely seen, and I don't think I've seen this in a flaw case, and especially where the petitioner has shown that they would not be able to afford based on their resources. I don't think there's, you know, ever been a court to do this. So that's a minimal risk. But other than that, the costs that Tamara mentioned are probably the most common ones you'll see.
Thank you so much. Donato, if you don't mind, we only have about 15 minutes left. I would like to take a couple of other questions, and then if you don't mind, we'll come back to you,
Yes,
Donato.
yes.
Thank you so
No
much.
problem.
I
Thank
see
you very
some
much.
other hands raised. We also have some written questions. We have about 15 minutes. Maybe we can take an extra 5 minutes afterwards, but I see Lucy Mulenke's hand is up. So Lucy Mulenke, please introduce yourself. Thank you so much.
Thank you very much, Alejandro. My name is Lucy Mulenke, Indigenous Information Network, and I really enjoyed the discussion. It was very relevant for many Indigenous peoples who are facing a lot of problems in different ways related to the subject. Now, my question is mainly on implementation, because as Kobe had already indicated, it took very long for them to put up their case, for them to be, you know, heard even at the domestic level. And when it went to the regional level, it was still difficult for the government to really take up the issue seriously. The implementation problem is always the problem. What can be, is there a way that Indigenous people at the same time can be able to kind of have an alternative, not only with the rapporteur, but maybe something that could be able to help them be able to move forward, especially where government is not taking up the implementation problems of the instruments which they have already ratified. Thank you, and thank you so much. And we also look forward to receiving the presentation. It was very important.
Thank you so much. I hand the floor over to Tamara and Upasana.
Implementation or just generally cases within the countries.
Oh, okay.
So I guess I mean we see the issues with implementation a lot in our cases as well. I don't have a clear answer in universally how implementation can be enforced. I think part of the issue with enforcement of judgments, is why EarthRights has tried to target cases involving U.S. links and trying to keep those cases in the U.S. Just because, not passing judgment on the judicial systems of other countries, but in the U.S., if a party doesn't comply with a judgment, they will be penalized, and it is a fairly timely process in enforcing a judgment. And so I think you raised a very good issue that, unfortunately, maybe Tamara has other thoughts. I don't have a clear answer to how you can enforce a judgment in any country, but I think that's why choosing the appropriate forum is very important in deciding your legal strategy. If you can, not necessarily a case in the US, if you can bring it to a case in another country that there's a link with that might have a stronger judicial system, more impartial judicial system, then that's often a very important part of strategizing the case. If you can find a link to a European country, even if the company is Royal Dutch Shell and based in the Netherlands, like maybe the alternative is to sue in the Netherlands and sue in a court system where the parties will actually be penalized if they don't carry out the judgment. Because it, like you said, it is often the states that refuse to implement these judgments, even if they're against a private party. And in that case, unfortunately, the main solution is often finding a different court system altogether. I know this isn't a very promising answer. Do you have anything to add?
Yeah, just a couple thoughts. I mean, I think it would depend also on what the country that we're talking about. One option could be, if it's a judicial proceeding, going back to the court to try and, obtain contempt of court findings, or if there's a transnational actors involved, if it's, let's say, if it's a parent company subsidiary situation where the parent company has enough control, there could be consideration to go get enforcement. Let's say if it's injunctive relief in the foreign country, as well if it's compensation that's been awarded, if there is international elements or actors, there could be the ability to try and enforce that judgment elsewhere. Mm-hmm. So that's something to consider. And one thing is, if we're looking at UN mechanisms, such as like the complaints through the UN, which, as I said, are not binding, so they can't force implementation. But what they do, at least through the individual complaint process, is require follow-up. So they will monitor the state's performance and will require the state a number of months later, I think it's 120 days or something like that, but it could vary depending on the body, to submit a report on what they've done to implement the recommendations. So, again, they can't require enforcement, but at least when there's pressure and potentially public pressure, that might be a mechanism. So I think it will, be a very fact and case-by-case based scenario.
Yeah, and unfortunately, I don't have much experience in the African Commission, in the African Union, but in the Inter-American Commission, like Tamara had said, when the Inter-American Court passes a judgment, there are periodic evaluations of a state's compliance. And so that, again, it's not the most efficient means of redress, but that also opens new avenues to participate. And, even if you're not a party, you can file briefs, as we did in a recent case, in reference to a judgment against Ecuador, to highlight deficiencies of that state. And so the regional body will then add pressure on the state, as it has in the Inter-American system. I don't know if there's a parallel mechanism for that in the African Commission, but I think maybe Danielle would be a better reference than me on that point. But yeah, so there are other means of exerting pressure the success of which is very dependent on the receptivity of the state. Yeah.
Thank you.
Thank you.
Thank you very much. Thank you. Thank you, Lucy, and thank you, the presenters. We have a hand up here, and then I do want to get some of these written questions to you, Upasana and Tamara, but let's start with Moha Hadush. If you could please introduce yourself. And I do just want to remind everyone we'll have 10 minutes and then we'll have to close this webinar, unfortunately. So Moha, please, if you're there. Hello? Oh, I don't know if she's there or he's there. Moha Hadush, please. Are you there? Okay, all right. Maybe that person is now offline. I don't know. And we do have another hand up, and this is from Sonigitu Ekpe. Are you there? Hello? Well, this person has also sent a written question, so I will read the written question. How do we address these issues at subnational level in line with NBSAP? I don't know if
Hello.
Hello. Hello, who do we have on? Yes, please introduce yourself and ask your question. Thank you.
Of forestry, biodiversity, marine protection and conservation. And I do have a little concern as it involves the issues around this scenario, especially where we have a case in the Niger Delta, and Nigeria has not rectified issues around indigenous people. How can we go about solving those few challenges you have outlined?
I'm sorry, which specific, moving forward on which specific issues?
In terms of rights in Pakasi Peninsula, where the government has ceded the peninsula to another country, and the citizens there do not want to move. And we have concern to create a marine protected area within the peninsula. And we are having, and the Green Tree Agreement is not being kept by the Cameroonians. So in that kind of scenario, how do we solve these challenges? Because the case in question is between a subnational state and an international community, while the national government is far away from the place.
Sorry, I missed the last part.
The last part I'm saying, the challenge we are having between the Cameroons, we have the subnational, which is the immediate state that has this challenge with the international community in terms of Cameroon. And then Nigeria has a Green Tree Agreement. And we have the issue that indigenous people within natural habitats, but then Nigeria has ceded this area to the Cameroons. How do we solve such scenarios?
These are land disputes.
Yeah, I mean, so I'm not exactly familiar with what, maybe domestic options may or may not be available, because land disputes often do require like local attention, but, and I don't know what treaty bodies necessarily Nigeria or maybe Cameroon are party, but there, you could look to, relevant rights that are implicated in this fact scenario, and that might fall within other treaties if they're not, let's say, if they haven't ratified, maybe like, or they're not participating in their the Declaration for the Rights of Indigenous Peoples, there could be treaties that they've signed on to that, do involve protection of land rights, and there could be advocacy that you could target around this scenario getting, increased attention to it, if that's, something that you're looking towards. But it's hard to really say exactly what, what strategy would be of use without really knowing more details on some of the specifics.
Yeah, I think a little clarification, if you may permit me. You found out that we are the first country in Africa to cede our land to another country. Now, this was as a result of the judgment at the Cameroon.
We lost you there a little bit.
Where was the judgment?
The judgment at the Hague ceded a section of Pakassi Peninsula, which formerly used to be in Cross River State, to the Cameroons, as a result of some other issues that had generated for a very long time. And there are a lot of challenges that either there are some bias at the Hague or something, but no one could say. But Nigeria went ahead to hand over the peninsula. But the citizens in those locations said they were not going to leave Cameroon. Their rights are being violated. And there was a Green Tree Agreement that now gives cooperation between Nigeria and Cameroon. But that Green Tree Agreement is not being kept. And this area is where we have our high biodiversity, rich biodiversity area. It's just at the Gulf of Guinea, the trigger of Africa. And you could see the peninsula is quite very rich.
If I may just intervene here, I think this is a very important and interesting issue and concern. Given our limited time right now, perhaps I invite you to perhaps send a written question directly to Upasana and Tamara, and maybe to the EarthRights International organization, to see what how these matters can be addressed either regionally and internationally. But in the interest of time, I apologize, but I think the best way would be for a bilateral discussion to take place between yourself and EarthRights International.
Yeah.
Okay.
Yeah, thank you to Alejandra. And yeah, just to clarify, I've worked more in the Americas, and Tamara as well, more in the Americas issue, but we do have allies, including former ERI members who might be more knowledgeable on the subject, and so we're happy to connect you to them if we're not able to address this ourselves.
Yes.
Thank you.
Thank you so much. We've also received quite a few questions that are the written questions. Some of them have to do with being able to get in touch with EarthRights International. So I just wanted to reiterate that we, and with your consent, Upasana and Tamara, to send you perhaps have your email available, or EarthRights International, some sort of I don't know if there's a general information email that can be sent to our registrar of the people who have registered for this webinar, so that they can contact the organization directly, and yourselves, of course.
Okay,
would that be okay with you?
Yes, we're happy to share our emails. Sometimes with various field travels, we might not be the most responsive, but we will, eventually, hopefully timely, get back to you, and definitely connect you all to appropriate allies if we're not able to help directly on these matters ourselves for lack of experience or whatever the reason. We have a large network of other lawyers that work on these issues as well.
I'll just, because we're going to have to close this session, but I do want to honor the written questions. I just will read them out, and perhaps I can ask our presenters if they can just give a very, very short response. So one question that we had was, do you have any examples of European, African, or Asian regional legal mechanisms being used to defend Indigenous people's rights? That was one question. And then another one, which is quite long, I will read it. In your experience using the legal strategies that you raised today when harms are experienced by communities, to what extent do you find the companies adapt their approaches as a result of the court's decision? And do they make changes as a result to prevent future harms for Indigenous and local communities? And is there a lasting result beyond the compensation of the peoples affected by that particular grievance? And I think that also relates a bit to the question that Lucy was asking on implementation as well. So then the person who had raised the hand, but then we were not able to connect, the question was, is the SDG 17 the Sustainable Development Goal number 17, which is about partnerships dealing with these issues? That was the question. And then we have a question, and I think we're addressing the question here we have from regarding the Nigerian-Cameroonian dispute. Okay, so I will kindly ask each of you to perhaps answer those questions very, very briefly, as we'll have to close this webinar. Thank you. Upasana and Tamara.
So one thing quickly, so I mean, I'm not gonna address all the questions, but one thing I did want to say about the question about changing corporate behavior in response to court decisions is that, you know, depending on the case, what the court or the facts, and whether it's past harm, future or ongoing and future harm, the remedy sought in the court case can vary. So in some cases it is compensation, but also cases have included requests for injunctions, so to prevent ongoing harm. And so the cases aren't limited to compensation, but that can be one part of, particularly if this involves, you know, ongoing and future harm. Another thing to consider is, you know, that the court case is only one element. So there's other strategies that can be adopted and worked on together with the case to, you know, change behavior and, you know, seek remedies that, or seek changes that might be broader than what the court case is targeted to. So yeah, I just did want to mention that it's not limited only to compensation, but it will depend on the specific case.
I guess to address the question of other regional mechanisms, again, my practice has been mostly in Latin America, and so the Inter-American system is what I'm most familiar with. I understand that the African and European human rights systems are pretty comparable. Unfortunately, I don't know the specifics on how they operate, but I can say that especially related to our flaw strategy, there have been cases before the European Commission and the European courts that have been linked with, actually, I think Intel was one of the main Supreme Court cases that set a lot of the standards for bringing, discretionary standards for bringing flaw, arose out of a case from the European Commission. And so those human rights cases often, you know, there's a strategy at the regional level, and from my experience, it looks like European Court of Human Rights, European Commission decisions have at least had a better track record in terms of implementation. even more so than the inter-American system. But the fact that you can then also supplement these actions with strategies such as the foreign legal assistance to supplement cases in Europe, in the European Commission, by then gathering evidence in the US, for example, just shows a way where you can combine these regional bodies with actual US statute. In terms of so as Tamara said, we do have offices in Asia, both in Thailand and Myanmar. We all were recently there just last month on a staff retreat, and we have very capable people at those offices that know a little bit more about the regional systems. But I do know that something that's very strategy that's important in Asia that is very parallel to what happens in Latin America is when there are governments that are unreceptive to human rights allegations, that kind of thing. For example, the government of Laos, what's been important for them is to look at the domestic or regional bodies that are receptive. So for example, if there is a project in Laos, what our allies or what our partners, our colleagues at the Asia office have done is look to whether, this oil project, for example, or a dam in Laos, whether it can be linked to transmission lines or to companies that will ultimately get this energy in Thailand. So when there is a country that's unreceptive to human rights litigation, Laos actually has only a dozen or so lawyers even practicing in the country. That's where our partners usually turn to the legal systems of neighboring countries if they can link a violation to either the existence of pipelines or transmission lines in the other country. So again, I'm happy to connect you to partners that would be more well-versed on these different Asian, African, European mechanisms. I familiarity with the Sustainable Development Goal. Again, I'm happy to look at these questions as well as the Nigerian-Cameroonian dispute more
and Tamara for your very, very thorough presentation and for launching our webinar series. We also invite the participants to send in their questions directly onto the NBSAP forum, because we will make the presentation available on the NBSAP forum, and it will also be, the webinar recording will also be available on the NBSAP forum YouTube channel. The recording link with the copy of the presentation is going to be posted on the forum homepage. So please, we invite you all to engage virtually now through the forum website. Thank you all very much. I hope you've all benefited from this session, and thank you also for the active participation during the question and answer period. Our next webinar will be this Thursday, and it will be in Spanish. We will again be looking at issues around legal frameworks and human rights issues related to Indigenous peoples and local communities. And then we have more webinars taking place throughout the month. So thank you very much, and thank you very much to EarthRights International and the work of your organization, which is having such a great effect on Indigenous people's livelihoods. Thank you.
Thank you so much, Alejandra, again, for having us.
Yeah, thank you, Alejandra, and everyone for listening and for your questions. And yeah, please do feel free to contact us if you wanted to discuss anything further.